calling our last case of the morning, People versus Mario Jackson. This is a mini oral argument on the application. Each side has 15 minutes of argument. My understanding is that Miss Matthews, you're going to be arguing on behalf of the prosecution?
Yes.
Okay, so you have a 2-minute fire-free zone, which you may waive, and also you may reserve any time that you would like for rebuttal. We just ask that you try and keep track of it. So begin whenever you are ready.
Good morning, Your Honors. May it please the Court, Shamiqua Matthews appearing on behalf of the appellate in this matter, the people of the state of Michigan, and I will try to reserve 2 minutes for rebuttal. MCL 777.33 scores the consequences of a defendant's criminal conduct, which considers the effect that the defendant's actions had on the victim. The statute specifically directs the trial court to score 100 points if death results from the commission of a crime and homicide is not the sentencing offense. In this case, the Court of Appeals wrongfully held that McGraw was controlling in this case rather than Laidler. Laidler was decided 3 years after McGraw, and in deciding Laidler, this court didn't see the need to mention McGraw because McGraw is not an issue in the scoring of OB3. OB3 places its focus on the physical injury to the victim. When looking at the language results from in OB3, the court must ask, but for the defendant's conduct, would the results have occurred? The but-for test essentially considers a hindsight review. The starting point is the defendant's sentencing offense, and we look at, had the defendant not committed this sentencing offense, would this harm have occurred to the victim? And establishing the factual causation is something that's relatively easy to do. The case law, it says that there's nothing in the statute that says that there may only be a single but-for cause. So essentially, there may be multiple but-for causes. So what we look at is if the defendant's actions was one of the but-for causes. And it's not disputed that OB3 considers the factual cause and not a proximate cause. So when we consider the proximate cause, that's when we start considering intervening acts. We look at negligence, how far removed the results were, and even foreseeability. But the factual cause, which is what we look at in OB3, it doesn't consider any of this. The factual cause focuses on the outcome. Would this outcome have occurred? And there's a case that is not included in the brief, but I think is important to consider. It's U.S. versus Ramos Delgado, which is 763 F3D 398. It is a Fifth Circuit court. It's a 2014 case. But I think that case is important because in that case, the court explained just how far the but-for cause can extend. And in that case, Ramos Delgado, the defendant in that case, he was convicted of illegally transporting the victim into the U.S. And in that case, the court considered the fact that if the victim was being transported by the defendant, fell off the truck, sprung his arm, and was taken to the hospital and later died at the hospital from a gas leak that was at the hospital, that there's multiple but-for causes for that victim's death in that scenario, but the defendant is still a but-for cause of that victim's death because had the defendant not committed that crime, that victim would have never been at the hospital to die from that gas leak. And I think it's also important to remember that this isn't scoring the OVs, which is a preponderance of the evidence, and is also, the sentencing guidelines is no longer mandatory, it's advisory. So that trial court that has the discretion to look at this and issue a sentence based off of considering everything that defendant was involved in this crime. I do want to kind of switch over and talk about who's considered a victim because that was the second point. In the statute, it doesn't directly define who's a victim. So when that happens, what we have to do is look at the plain dictionary definition of who's a victim, the definition of a victim, and we also have to look at the legislator's intent. And in this statute, OB3, legislators, their intent is to use a but-for cause because it says result from. So whenever we use results from, it's a but-for cause. So My argument is that we use that same but-for cause to satisfy the legislator's intent in deciding who's a victim. And in this case,
Counsel, you're suggesting, I think in your pleading, that we don't look to the definition of victim in the Crime Victims' Rights Act, and I'm just wondering why we wouldn't do that. That seems like a natural place to look where the legislature has defined victim.
right, I think that's a place to look, but I think you also have to consider the statute as well in order to look at legislators' intent that's trying to be accomplished in that specific statute.
So why would we give precedent to a general dictionary definition over the definition in the CVRA, for example?
I'm not saying give precedent. What I'm saying is that because the statute doesn't specifically define it, we look at everything as a whole so that we can try to see what the legislator was trying to accomplish with this statute so that we can use them all together as a whole to accomplish that.
Counsel, just to clarify, when you're saying the statute, you're talking about the statute underpinning the guidelines.
Yes, the statutes with OV3 specifically, because there's other statutes that define what a victim is, but OV3, specifically the 777.33, it doesn't directly define, doesn't give a definition of what a victim is under OV3.
Even if we accept your but-for argument, the record here is rather sketchy. I mean, we don't know how much time, unless I missed it, we don't know how much time passed between the initial assault and the confrontation that resulted in the shooting. We don't know who shot the fatal bullet. So given this sketchy record, isn't it more difficult to arrive at the conclusion, even if we accept the but-for standard that you're advocating for?
I do agree that the record is not as ideal as we would hope for it to be, but I do think that there is enough in the record to succeed the but-for test, because essentially the but-for test, it looks at if we can magically wave this wand and say, let's go back as if the defendant never committed this sentencing offense. If he never did this assault, would this death have occurred? And I think it's clear from the record that we can say that had he not assaulted her, then she would have never had to reach out for help. She would have.
But for standard, whether we do it in this context of a criminal matter or in civil cases, there are intervening causes and intervening events that can take away from that. And we just don't know what happened. There's a substantial amount of time, as far as I can tell, between the time of the initial assault and this shooting. And there could have been other confrontations or other events that occurred that would be intervening. And with the, I don't want to speculate, but the fact that the record is so sketchy makes it very difficult to conclude, to reach that step, that but-for step.
Right. So I do believe that when we start looking at intervening acts, then that considers the proximate cause. So which in this case we're looking for the but-for test. And then I think the Court of Appeals did kind of speculate a lot because they considered that the assault was over because the victim's brothers had enough time to make it to the scene. But if we read the transcripts in this case, it also states that the defendant, he had a witness, Ms. Jackson. She testified that she was called by the defendant, she arrived at the scene, and her testimony was that she witnessed this assault. That when she arrived at the scene, that the victim's tooth wasn't knocked out, and she witnessed the defendant knock this victim's tooth out. So I think it's a stretch to say that just because the brothers had enough time to arrive at the scene that the assault was over, or that the assault happened so far before, because the defendant's own witness testified that she was able to make it to the scene and still see this assault go on.
So what if the brothers were, upset on behalf of their sister, and they went after the next day, and this happened? I mean, obviously it's because of what happened the prior day. Where do we draw the line on this? Obviously, that's sort of one of the challenges here.
And I think that's why that Ramos Delgado case is so important to look at, because it essentially says that there's no limitation on the but-for cause. Because the but-for cause doesn't have to be the single reason for something. It could be multiple but-for causes. All that has to happen is we look at the defendant, had he not committed this assault, would this outcome have happened?
So it seems like the Court of Appeals in sort of, I guess, managing Laidler, they seem to have layered in sort of implied temporal, it's related to the crime, it's sort of around the time of the crime, you know, which may or may not, you know, work for you or defendant here, but obviously we have to think about implication bigger than just one case, obviously. So is the Court of Appeals handling Laidler correctly with sort of that temporal limitation?
I think they're adding, so Laidler doesn't put on a stipulation as far as it has to be I think Laidler does the but-for test that I'm looking at. And a lot of the cases that were mentioned, even a lot of People versus Morrison, a lot of the cases, if you look at the outcome of it, the court strictly looks at but for the defendant committing this offense, not is this offense over, or it doesn't go into detail about that. It goes to if we can stop the defendant from committing this sentencing offense that he's convicted of, would the death have occurred? And I think that's very important for us to look at, and I think that's what the statute directs for us to do, to look at if the defendant would not have committed this sentencing offense, would the death have occurred?
Do we know she wouldn't have called her brothers for a ride without the sentencing offense? Like that, I think that's why this case is hard, because we don't really know that they wouldn't have been there or this wouldn't have happened to them without the sentencing offense.
Well, I think if we look at, had he not, because in hindsight, which is what the but-for test looks at, had he not assaulted her, she wouldn't have had the need to call someone to come and help her and call to rescue her. And it's not that the defendant is the only but-for reason. It could be multiple but-for reasons, and I think that's something that's important to consider. There can be multiple but-for causes. It's just that the defendant is one of the but-for causes. And if there are no additional questions, I will reserve the rest of my time. Thank you.
Thank you.
Good morning, Madam Chief Justice, Your Honors, and may it please the Court. Angeles Meneses from the State Appellate Defender Office, joined by co-counsel Jessica Zimbelman on behalf of Mario Jackson. Your Honors, for most of her argument, the prosecutor did not reference any of the facts that took place in this case, and that is because there was no evidence presented here by the prosecution about the circumstances leading up to and causing the shooting death of Mr. Ely, let alone evidence beyond a preponderance of the evidence as established that's required by this court in People v. Hardy. This court should deny leave to appeal in this case because this state's jurisprudence and the statutory scheme underlying the guidelines make clear that offense variable 3 is a McGraw offense-specific variable. Only conduct that occurs within the sentencing offense can be considered in scoring OV3. And in contrast to what the prosecutor argued, there is no tension between this court's decision in Laidler and its decision in McGraw. Laidler only considered conduct that occurred during the perpetration of the sentencing offense. And so Judge O'Brien in the Court of Appeals was correct to point that out, that there is no tension between those two opinions in her concurrence in the Court of Appeals. I'm open to this court's questions at any time. Your Honor, a couple of brief points. So the definition of victim, as to Justice Thomas's question, the definition of victim that we are operating under here is any person harmed by the criminal actions of the charged party. And that is correct. It is not necessarily the definition offered by the Crime Victims' Rights Act. It is the definition that is cited in Laidler and that is used in the statutory scheme underpinning the guidelines. The prosecutor cites U.S. versus Ramos Delgado, which is, for the record, not a binding case on this court. It can be a persuasive case on this court, but is a Fifth Circuit Court of Appeals case. However, that case falls squarely in line with Laidler, because that conduct that is alleged to have caused the death of the victims in that case occurred during the commission of the sentencing offense, which was transportation of undocumented persons. So those injuries which led to that person's death resulted as a result of the sentencing offense. So actually, the reading of that case would fall squarely in line with what this court established in Laidler. There is no record evidence here showing that Mr. Ely was harmed by Mr. Jackson's criminal actions. All we know from this record, as Justice Zara pointed out, the record here is very spotty. All we know is that at some point after the assault of Ms. Ely was complete, which Ms. Jackson did testify that she was present for. At some point after that, Mr. Ely is shot and killed. The prosecutor had all the discretion to charge Mr. Jackson with the shooting death of Mr. Ely, but they elected not to. And that was something that was pointed out by the trial court at sentencing in discussions about whether or not to score offense variable 12. That the prosecutor had purposely elected not to charge this conduct, but then was arguing that it should be used as felonious conduct under offense variable 12. Moreover, Mr. Jackson's commission of the sentencing offense here was not a factual cause of Mr. Ely's death to warrant a 100-point score under offense variable 3. We agree that, yes, it is not, it is but-for causation that is required. We do not necessarily need proximate causation. But what the prosecutor's logic is asking us to adopt would lead to absolutely absurd results. It would lead to, for example, a situation where, hypothetically, someone could steal a car and sell it to a second person. And then weeks later, unbeknownst to that first person, the second person is driving the stolen car and kills somebody. By that logic, that person's death was proximately caused by the theft of the automobile. That is incredibly far-fetched.
You basically want us to put limitations on how attenuated a death can be from the sentencing offense to justify the 100 points. And I get that, and it makes sense. All right, you're writing the opinion. What is it? How do we draw the lines? How much time can pass? What has to be associated with it?
And Your Honor, we're not asking for any kind of temporal requirement here, because here we actually have no evidence as to how much time or what amount of time transpired. Here we're merely asking this court to reaffirm what it held in Laidler and what it has held time and time again, that because offense variable 3 is offense specific, only conduct that underlies the sentencing offense can be considered when deciding whether a score is warranted for that offense variable. And so here we have no evidence, let alone beyond a preponderance, that Mr. Jackson's actions or commission of the sentencing offense caused the death of Mr. Ely.
That avoids my question. If we want to say that it can be something greater than that, but there has to be some association, how attenuated can the death be? You follow what I'm saying?
I do, Your Honor. And the only parameters that have to be set are that the death must result from actions underlying the sentencing offense. No temporal requirement needs to be established. It could be, there are situations where...
So the death must result from the assault. But for, and we're still taking but for from Laidler, I assume, right? But for this assault, would these two men come to defend their sister?
But respectfully, Your Honor, that's not the test here. With Laidler, what Laidler specifically held was that the act of pushing someone up into the window, which occurred as a result of the perpetration of the sentencing offense, led to that person's death, and so that death could be scored. Here, we have nothing, it could potentially be inferred that the brothers would not have come to the scene had that not happened, but we really don't know what happened that day. We have no evidence regarding the circumstances of the shooting here, only that a shooting occurred and that someone passed away, unfortunately. And so we don't have anything that would, indicate, let alone anything temporal, anything connecting Mr. Jackson to the proximate cause of this death.
But Laidler, obviously what the Court of Appeals has sort of drawn from it and inferred is it kind of all happened in the same time range. It was part of the same, maybe it's to your point, the sentencing offense, I don't know, but, lifting you up in the window, they're in the middle of committing the crime. It seems like that's what the Court of Appeals has sort of drawn from it to try to create some sort of parameters.
The Court of Appeals has emphasized that part of the reasoning in Laidler, Your Honor, but also that is what the holding of Laidler is. There is nothing about Laidler that requires considering conduct that occurs outside of the sentencing offense.
Well, what do we do with the language of OV3? It doesn't say if the death results from the commission of the sentencing offense, and a homicide is not the sentencing offense, from the commission of a crime.
Yes, Your Honor, it does say results from the commission of a crime, but that language, based on how the legislature has interpreted or written the guidelines, and based on this court's interpretation of offense-specific variables, including offense variable 3, that is only to include commission that results from the sentencing offense here. And so there is no language in the statute, as there are in other offense variables, that allow us to consider conduct that occurs after the commission of the sentencing offense or outside of that. If the legislature had wanted that, they would have clearly done so as they have done in other variables.
Okay.
If there are no further questions, I will sit down.
Thank you.
Thank you.
Ms. Matthews, you have 3 minutes and 50 seconds for rebuttal.
I will be very quick, unless there's any other questions. I just want to focus on the results from, what the results from says, and I think that's the most important to look at, and it says results from the crime. So we're looking at, had this crime not been committed, would this death have occurred? And I think that's what's the most important thing to focus on here, is that but-for cause. And it's looking at the crime, not the conduct of that crime. And I think when we look at all of the different cases, what's being looked at is the crime itself. Had this crime not happened, had the defendant not committed this crime, would the death have occurred? And I think that's the focus of this case. And if there's no other questions, then thank you.
Thank you. The case will be submitted. And the court stands adjourned for lunch.